You're watching The Legal Breakdown. So, Glenn, we've got the single most important piece of news here with regard to Donald Trump's DC criminal trial. So, he's been claiming presidential immunity, which would end his prosecution effectively. And that was already shot down by Judge Chutkan in the district court. But now we've got news about the final arbiter of this question, and that is the Supreme Court. So, what's happening now?
Yeah, really interesting news. Jack Smith is trying to leapfrog over the appellate court, bypass them completely, and get this right into the hands of the Supreme Court justice. And he says his reason for that is what he calls the imperative public interest in a timely trial. This is an unusual move, but it's not unprecedented. This kind of expedited review and sort of leapfrogging over the appellate court right into the Supreme Court has happened a number of times in recent years, but it is certainly out of the ordinary course of appellate business. But Jack Smith has made clear he's going to pull out all the stops, both procedurally and substantively, to try to keep to that March 4 trial date, because he understands, I think, the burning interest and the burning need to resolve this issue, this criminal trial of Donald Trump, well in advance of the November 2024 presidential election. And that is what is behind today's move.
So, how certain is it that the Supreme Court will even take up this case?
Certain is not a word I'd use. Likely is perhaps a word I'd use, though I'm still hedging my bet a little bit. It is anybody's guess as to what the Supreme Court will do. Let's tick through a couple of the possibilities. They could say, we are refusing to accept this case for review without comment. Well, that would leave us all scratching our head, because on the one hand, that would mean, well, they obviously don't disagree with Judge Chutkan's resolution of this case, and her resolution of the issue is President ain't king and he can be tried for his crimes. So if the Supreme Court just says, we're not touching it, at least not at this moment, that would seem to, at least inferentially, lead one to conclude that I guess they're okay with Judge Chutkan's ruling in the case that he can proceed to trial. But here's kind of the wild card. If they do that, well, the case is still pending appeal in front of the DC Federal Circuit Court of Appeals. So all they will really succeed in doing, if they choose not to touch it at this time, is let it run its ordinary course through the Court of Appeals. Now, mind you, Jack Smith simultaneously with this petition seeking to have the Supreme Court review it immediately, he simultaneously filed with the appellate court, the lower appellate court, a request to expedite that appeal as fast as humanly possible. So right now, Jack Smith is firing on all procedural cylinders, trying to get this thing to trial.
Now, if the Supreme Court does opt to take it up and they rule, for example, that they agree with Judge Chutkan, does Donald Trump's team have the ability to appeal anymore, or is it final? Like it was never heard by the circuit court, so can they appeal back to the circuit court? Or once it's leapfrogged, Supreme Court is the final arbiter of this decision anyway, and there's no more appeals that could be had?
What a great question. I've been talking to some of my far smarter colleagues that I used to prosecute cases with. And I think the consensus is, and I think this is right, if the Supreme Court accepts review of this, and I think they're likely to, because I think the Supreme Court wants to be a player. And I think they want to be a player in a way that will resolve this issue while still honoring the rule of law. You can only honor the rule of law if you find that a president who commits crimes, serious crimes, democracy-busting crimes, while in office, must be held accountable. There has to be a vehicle for accountability for those crimes. So I have a feeling they're going to accept review, and I hope that they have a loyalty to the rule of law and to the health and well-being of our democracy. So if they accept review and they decide it, they have sort of cut out the middleman. They have now taken the DC Federal Circuit Court of Appeals out of the mix, because whatever the Supreme Court says about the issue would bind the DC Federal Circuit Court of Appeals anyway. So this would be a way to kind of get the issue resolved definitively. The next question is, will it be resolved quickly?
To that point, what is the timeline for the Supreme Court to both, one, confirm that they're taking up the question, and then two, when they'll actually make a decision on that question?
I think they will let us know whether they're accepting review of the case or not pretty quickly. Could be within days or within a week or two. And then the best we can do is sort of some informed speculation about how quickly they can resolve the issue. I think everybody understands that time is of the essence to get this issue resolved. Can a president commit crime with impunity? And let's think about what that means. A president could invite his political opponents into the Oval Office, and I hate to be indelicate, but shoot them through the head,
Right.
do away with them. Hence, he no longer has any political opponents. And the Supreme Court would rule that he has absolute immunity. So that's just fine. That's just part of our constitutional construct. I mean, I just cannot envision an America or a Supreme Court where that becomes the law of the land. But whereas the Supreme Court, I think, appreciates the urgency of the moment and will, I think, feel a pressure to decide it quickly, I just hope, Brian, that their ideology, and when I say ideology, I'm not talking about their proclivity, in how they're going to interpret the Constitution. I mean their political ideology.
Right.
I hope it doesn't interfere, and I hope they don't sort of help Donald Trump run out the clock while they think deep thoughts and engage in endless analysis of the issue. I don't think they will. Again, I'm not a betting man. I would probably put 50 cents on them resolving it quickly such that the March trial date will hold. But, it's a push. It's anybody's guess.
Glenn, is there any precedent that might inform how the Supreme Court would rule on this?
There's no precedent, but there is a lack of precedent. What do I mean by that? There is absolutely no support in the law. In the law, in all its forms. The law can be a statute, something passed by Congress and signed into existence by the president, granting government officials immunity against prosecution. There's no law. There's no appellate court opinion. There's no precedent, which we call case law, suggesting that a president has any immunity for crimes he commits while in office. And importantly, there is absolutely no constitutional provision that directly or implicitly suggests a president cannot be prosecuted for crimes he commits while in office. So the absence of law, the absence of precedent, the absence of any constitutional support is in and of itself a kind of law. There is a support out there for the notion that there is absolutely no viable support for the legal claim that a president can't be prosecuted. I won't spend too much time going to the civil doctrine of immunity for a president because there's a healthy dose of civil immunity, and that actually makes a lot of sense. The last thing we want all of our government officials to have to suffer is spending all day, every day in court defending against civil suits brought against them by unhappy citizens who might disagree with political decisions that have been taken.
Right.
But there has never been any case law that says that civil immunity needs to be imported into the setting of a criminal prosecution. It's just not there.
Glenn, were you encouraged by this move by Jack Smith, and were you surprised that he took this step?
I would say I was not at all surprised, because if there's one thing Jack Smith has proven time and again, he shies away from no fight. He has been really going hard after accountability for the crimes of Donald Trump. He has fought every battle. He has shied away from no battle, up to and including forcing Donald Trump's own lawyers to testify in the grand jury against him, forcing Donald Trump's former vice president to testify in the federal grand jury against him. And I'm quite sure all of those people will be subpoenaed to testify against Donald Trump at trial. So no, Jack Smith is going hard after accountability and after justice. Encouraged? Absolutely. Because everything that we were just discussing about just how aggressive, appropriately aggressive Jack Smith is doing is encouraging, because this is the kind of case, unprecedented as it is, that federal prosecutors could lay back and feel uncertain about how they should proceed. Not Jack Smith. He sees the goal. The goal is accountability and justice, and he is going after it full bore.
And finally, let's end with this. Is there any influence that Judge Chutkan could have on the Supreme Court? Like, for example, if she were to go forward and say that, to reiterate Jack Smith's imperative that this case be decided on quickly.
There really is no influence that she holds at this moment, in part because once this kind of an appeal is filed, it's called an interlocutory appeal. That is a legal mouthful. All it means is that almost every appellate right a defendant has doesn't even come into existence until after the trial, the conviction, and the sentencing. That's when a defendant ordinarily gets to appeal whatever it is that went on in his case before the trial and during the trial. But because this issue is what we call a case dispositive issue, an immunity issue, because look, if he has immunity and he can't be prosecuted, he should not be made to even take one step
Right.
on the road to his trial. But given the nature of this kind of an appeal, once it's filed, because it is case dispositive, everything in the trial court stops. So in other words, Judge Chutkan really doesn't even have jurisdiction to continue to move forward and do much of anything in her case. Now, they can still, have some discussions and litigation about the gag order or discovery disputes or sort of preliminary matters, but they can't really move in the direction of the trial proper. The judge doesn't really have the authority anymore because now the authority has already vested up in the appellate court. So there's very little that Judge Chutkan can say or do on the record or otherwise that will impact what the Supreme Court is thinking at this point.
Okay, well, obviously at this point, all eyes are on the Supreme Court as we await their decision on this matter, and that decision will definitely have major implications moving forward, not just in this DC prosecution, but I'm sure others as well. So as soon as we have any news, any update on this, we'll make sure to bring it to you. So for those watching right now, if you want to stay up on this news, make sure to subscribe. The links are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.